So it is not violative of Article 300A of the Indian Constitution. Now, in an agreement, which is consisting of both affirmative and negative covenants. Yes, after that, after my sessions is over, you can post your question one by one, then I will answer. Now let me finish the lecture given to me. Suppose an agreement consisting of two parts. One is in affirmative, another one is negative. When the negative part can be enforced by the court of law, that is the point. What is the affirmative? What is negative? Suppose an agreement was entered into. It's an illustration. I will give my answer subsequently. An agreement was entered into between an employer and his employee, stating that the employee should work with the employer for a period of 5 years. And during the currency of the agreement, he cannot quit the job and he cannot work with the other employer or competing employer. This is the agreement. This agreement is consisting of two parts. One is to work with the employer for a period of 5 years. Condition number one. This is affirmative in nature. Second one, negative agreement not to work with any competing employer. You should not work with the other company. The point is, the employee left the company and joined the competing company. Now, can the employer file a suit for specific performance, compelling his employee to work with his company for a period of 5 years? This is point number one. Suppose he don't want the employee to work with him for a period of 5 years, can the employer file a suit for injunction for the enforcement of the negative covenant directing the employee not to work with other company for a period of 5 years? This is illustration. You just keep it in mind, and I will answer these questions one by one. So, when an agreement is containing both affirmative and negative part, normally the court cannot enforce the negative part of the agreement straight away. This was the law prior to 1852. This was the law prior to 1852. But first time, the King's Court in England changed the view. When the court could not enforce the positive part of the agreement, so it is a personal service, the court cannot compel the employee to work with him, because if there is a breach, damages is the adequate remedy. So when the adequate remedy is available, the court normally refuses to grant a degree for specific performance. So the positive part cannot be enforced. When the court could not enforce the positive part of the agreement, but still it could enforce the negative part of the agreement. This is the first time the law was laid down by the King's Court, Lumley versus Wagner 1852, 1 DGM and G, page 604. This is the first case on this subject for the enforcement of negative covenant. When the court is not in a position to grant a relief of specific performance for the enforcement of the positive part of the agreement, it could grant a degree for permanent injunction for the enforcement of the negative covenant. Now, next question is, normally a suit for specific performance must be filed for the enforcement of the positive part of the agreement. When the court comes to a conclusion that for other reasons, the court is reluctant or not in a position or not inclined to grant the relief of specific performance, it may grant other relief which is prayed for. So when the court comes to a conclusion that the positive part cannot be enforced, then it could grant a degree for permanent injunction for the enforcement of the negative covenant. Now, here the point is whether a suit for enforcement of negative covenant is maintainable in the absence of the prayer for the specific performance of the positive part. So, a suit for specific performance must be filed for the enforcement of the positive agreement. When the court comes to a conclusion that it is not possible to grant such relief, then only the court is entitled to grant the relief for the enforcement of the negative covenant. That is the law. But our Delhi High Court, in Frank Simos Advertising Private Limited versus Tata Leasing Industries Limited, because you can post the citations in the chat box. AR 1988 Delhi, page 302. Mr. Vikas? Okay, he's not connected. Okay. AR 1988 Delhi, page 302. I'll ask Vikas to post the citations later, and you can note down the cast title, party's name. Then there, our Delhi High Court said, a suit for enforcement of negative covenant is maintainable even in the absence of prayer for the specific performance of the positive part of the agreement. Now, in a suit for enforcement of negative covenant, in whose burden it is, who has to prove? The burden of proof is on the person who pleads that there is no negative covenant, either express or implied. The famous case in this field is Gujarat Bottling Company Limited versus Coca-Cola and others. This is a legal battle between Coca-Cola and Pepsi. It is reported in 1995 by SEC, page 445. 1995 by SEC, page 445. Gujarat Bottling Company Limited versus Coca-Cola. In this case, the Coca-Cola company entered into an agreement with the Gujarat Bottling Company they have to supply the syrups. They have to bottle it, fill it up, and distribute the same agreement. Another condition is the shares in the Gujarat Bottling Company cannot be transferred without the consent of the Coca-Cola. And another condition is that the agreement is for a period of 1 year. During the period of 1 year, the Gujarat Bottling Company cannot fill the syrups of Pepsi or other competing company. So this is negative in nature. So the Gujarat Bottling Company cannot bottle, fill it up, and sell it and distribute the same to the other competing company. Now, Pepsi acquired the major shares in the Gujarat Bottling Company. And after the acquisition of the shares in the Gujarat Bottling Company, the agreement, they issued notice to terminate the agreement. So, irked by that, Coca-Cola Company instituted suit before the Bombay High Court and filed an interlocutory application for various relief and including the relief of enforcement of the negative covenant, restraining Gujarat Bottling Company from bottling, filling, selling the Pepsi syrups. And that injunction was granted, and it was challenged before the Division Bench of Bombay High Court. The Division Bench of Bombay High Court has also upheld the order passed by the single judge of the Honorable High Court. Then the Gujarat Bottling Company filed SLP before the Supreme Court. Before the Supreme Court, it was argued that the negative covenant in the agreement is against the doctrine of restraint in trade, violating Section 27 of the Indian Contract Act. So under Section 27 of the Indian Contract Act, an agreement to restrain any trade, calling, or profession is void. So the negative covenant, the negative part in the agreement, restraining Gujarat Bottling Company from carrying on their business with the other company is void as per Section 27 of the Indian Contract. For that, our Honorable Supreme Court has said, partial restraint of trade might be good if reasonable, and it is not against the spirit of Section 27 of the Indian Contract. You entered into an agreement agreeing to do service to Coca-Cola for a period of 1 year, and during the currency of the 1 year, you have also agreed with your manifest and unequivocal intention not to do the same business with other company. So there is a breach on your part. There is a breach on your part. Normally, when an application is taken out under Order 39, Rule 1 and 2 of CPC for injunction, you, the petitioner, who is seeking an order of injunction, has to satisfy the triple test. The triple test is prima facie case, balance of convenience, and if the injunction is not granted, it would cause irreparable injury to the petitioner. Prima facie case, balance of convenience, irreparable injury is the triple points to be satisfied before getting an order of injunction. But our Supreme Court in the first time has also pointed out, no doubt the petitioner seeking an order of injunction must establish all these things, prima facie case, balance of convenience, and if injunction is not granted, it would cause immense loss and hardship. But at the same time, the person who is opposing the grant of injunction, that is the opponent, that is a respondent, he must be fair and honest. The conduct of the respondent must be fair and conduct. Here, as against the agreement, without the knowledge of the Coca-Cola Company, Gujarat Bottling Company transferred major portion of the shares in favor of Pepsi. That is a breach number 1. Second one, the agreement was terminated not by Coca-Cola. It was terminated by Gujarat Bottling Company. Third one is, there is an agreement, negative agreement, not to fill the syrups of Pepsi during the currency of the 1 year. So the breach is only on the part of the Gujarat Bottling Company. So the order passed by the Division Bench of the Bombay High Court does not require any interference. At this stage, last argument was advanced on the side of Gujarat Bottling Company that if the injunction is granted restraining the Gujarat Bottling Company from carrying on business, and then the company would become idle. There are more than 500 employees and 5,000 employees and 500 officers, and their plight has to be taken into consideration. Repelling such argument, the Supreme Court said the fault is on your part. On your part. The court has already said the negative covenant is not against Section 27 of the Contract Act, and the negative covenant can be enforced to meet out the ends of justice. So finally, the Supreme Court upheld the order passed by the Division Bench of Madras, Bombay High Court. Then another case. Normally, the court has to consider before granting an order of injunction whether the plaintiff has made out a prima facie case, whether the balance of convenience lies in favor of the plaintiff. If the injunction as prayed for is not granted, whether it would cause immense loss and irreparable injury to the plaintiff petitioner. That has to be taken into consideration. But in a suit for enforcement of negative covenant, first time the England court said the concept of balance of convenience and the damages being adequate remedy become less important. If the suit is for the enforcement of positive part of the agreement, then all those prima facie case, balance of convenience, irreparable injury will be taken into consideration. In a case for the enforcement of the negative covenant, it becomes less important. 1878 3 appeal cases 709. This has been followed by the Calcutta High Court in the case reported in AR 1996 Calcutta, page 67. Vijay Minerals Private Limited versus Vikas Chandra De. AR 1996 Calcutta, page 67. In that case, it is relating to the delivery of manganese ore for a period of 5 years, and there is a negative agreement. Yes, negative agreement, and the court has held for the grant of enforcement of injunction for the enforcement of negative covenant, the balance of convenience is less important. And the argument was advanced. Suppose if he can get the compensation for their damages. Normally, when the court is able to assess adequate compensation for the breach, then the court will be reluctant to grant the relief of specific performance. Here, the court is not going to grant the relief of specific performance. The court is going to grant a degree for permanent injunction for the enforcement of negative covenant. So that is why the court said the balance of convenience and the adequate remedy damages is the adequate remedy become less important. And in another case, I think it has not been reported, but we please take it out. Suresh Dhanuka versus Sunita Mohapatra, Supreme Court. In this case, our Supreme Court has held Section 42. Before that, I would like to emphasize one point. The defenses available against the grant of injunction, Section 41, when injunction can be refused. Some grounds are stated in Section 41, A to J. So these are all the grounds to refuse to grant a degree for injunction. Under Section 41E of the Specific Relief Act, injunction cannot be granted to prevent the breach of a contract, the performance of which could not be specifically enforced. When the court cannot grant a degree for the performance of when the court comes to a conclusion, degree for specific performance cannot be granted. Equally, it cannot grant a degree for injunction to prevent the breach of a contract. But Section 42, in its opening sentence, notwithstanding Section 41E of the Specific Relief Act. So, Section 42 is an exception to Section 41E. It contains non-abstanding clause. Even though specific performance cannot be enforced, still the court has got power to grant the relief for the enforcement of negative covenant. So in this case, the Supreme Court has held Section 42 is an exception to Section 41E, and it is not violating Section 27 of the Indian Contract Act. And another case, image, this is not reported, image advertising and another, Anand Prakash. This is Delhi High Court. In this case, an agreement was entered into between the plaintiff and defendant to display the hoarding and the neon sign in the place belonging to the defendant for a period of 5 years. And there is a negative agreement part that during the currency of the 5 years, the defendant, respondent company shall not allow other parties hoarding and display. Dispute arose, suit has been filed for specific performance and also for the enforcement of negative covenant. In that case, the judgment of Supreme Court reported in AR 1967 Supreme Court, page 1098, was referred. In this case, this is NS Golikari versus Century Spinning Company Limited. 1967 Supreme Court, page 1098. In this case, the Supreme Court tested the agreement between the employer and employee. At my introduction, I have illustrated that an agreement was entered into between the employer and employee. The agreement contains that the employee should work with the employer for a period of 5 years, and during the currency of the 5 years, he cannot leave and work with other company. Whether such a clause is against the doctrine of restraint of trade. Restraint of trade. The court said, no doubt this agreement contains two parts. One is affirmative part, that is directing the employee to work with the company for a period of 5 years. This is not against the doctrine of restraint of trade. No problem. But restraining the employee from working with other company is against the doctrine of restraint of trade. So this is relating to personal service. This has been argued before the Supreme Court. This has been argued before the Delhi High Court. And by citing other judgments of Supreme Court, Delhi High Court pointed out the employer-employee agreement is mainly relating to the personal service. It cannot be equated with the other commercial contracts. No doubt in this agreement of employer and employee, the aggrieved employer is entitled to file a suit for damages or get compensation, and he cannot restrict the employee from carrying on any other business, from working with other company. But that agreement cannot be equated, cannot be put on par with the other commercial contracts. Here there is an agreement. There is an agreement to permit the plaintiff to display coding and a neon sign in the place earmarked by the defendant belonging to it. And before displaying the coding and neon sign, it requires license from the municipality, corporation. The corporation will grant license only the owner of the property gives his no objection. No objection was not given by the owner. So the petitioner is not in a position to get license. This is due to the non-cooperation on the part of the respondent, because the respondent failed to give his no objection. And he is attempting to invite other parties to erect codings and neon signs in their place. So a suit for injunction for enforcement of negative covenant was filed. So though the court cannot enforce the specific performance, directing the respondent for the specific performance of the agreement, that is to allow the petitioner to erect his coding and a neon sign, but still, in as much as the agreement contains the negative part, the court is not powerless. The court is omnipotent. The court has got plenary powers to grant the relief of injunction for the enforcement of negative covenant. Ultimately, the suit was decreed. And another case, GVK Airport Holding. GVK Airport Holdings Limited versus Bid Service Division. This Delhi High Court order dated 1/7/2019. GVK Airport Holding Limited and Bid Services Division. In this case, the Mumbai Airport, Chhatrapati Shivaji Airport is being operated by GVK company. And the major shares in the Mumbai International Airport Limited, it was held by Bid Service Division. There is an agreement between the GVK company and the Bid Service Division that as and when the Bid Service Division is intending to transfer its shares the first priority must be given to GVK company. In other words, the GVK company has a right of first refusal. If the GVK is not willing to buy the transfer, then it can sell it in favor of any third parties. So the right of first refusal is given to GVK company. In other words, preemptive right is given to GVK company to purchase the shares of the bid service division, namely the shares of Mumbai International Airport Limited. The bid service division wanted to transfer their share in favor of some third parties. Agreed by the decision of the bid service division, GVK company filed a suit and they have invoked the arbitration clause, and they also filed an application before the Delhi High Court for various relief, including the relief of enforcement of negative comment. In this case, first time, Delhi High Court invoked the principles of readiness and willingness before granting the relief of negative comment. Normally, in a suit for specific performance, the plaintiff must establish that he is always ready and willing to perform his part of contract. From when? That is the point. In a suit for specific performance, it is imperative. It is incumbent on the part of the plaintiff to show that he is always ready and willing to perform his part of contract from the day one, that is from the date of execution of the agreement. The moment the plaintiff entered into an agreement with the vendor, he must establish that he is always ready and willing, that having sufficient financial resources to pay off the balance sale price, and his conduct is unblemished. This is 2013-15 SEC, page 27. I.S. Chikandar, debt by LR versus K. Subramani. There is no quarrel about it. Yes, the plaintiff has to establish that he is always ready and willing to perform this part of contract from the day one. And also, the plaintiff must prove his readiness and willingness. Readiness and willingness. Now, the specific relief part has been amended in 2018. Here, you need not aware that you are ready and willing. That part is deleted. But the plaintiff must prove that he is always ready and willing to perform this part of contract. Only on proof of his readiness and willingness, a degree for specific performance can be granted. So, the prerequisite for the grant of specific performance is to satisfy the court that the plaintiff is always ready and willing to perform his part of contract. What is the term readiness? What it means, the phraseology readiness and willingness. Readiness means the phraseology, it refers to the financial capacity or financial resources of the plaintiff to purchase the property from the defendant. That he must possess sufficient fund to purchase the property, namely to pay off the balance sale consideration. So he must prove that he is having sufficient funds to purchase the property. that is readiness. The willingness is a term referable to the conduct of the plaintiff. The conduct of the plaintiff has to be scrutinized along with the attendant circumstances. What is the date of the agreement? What is the period given to the plaintiff to perform his part of contract? Whether during the currency of the period, whether within the stipulated period, whether the plaintiff has performed his part of obligation, whether he has issued any notice calling upon the vendor to receive the balance sale consideration and execute the sale in his favor. These are all the conduct and the attending circumstances on the part of the plaintiff to show his willingness. So both the terms, readiness and willingness, are inseparable, having nexus with each other. So the key point to be proved before the court to get a degree for specific performance is the plaintiff's readiness and willingness, and he has to prove. But in the instant case, the GVK company, though referred the matter to an arbitrator and filed an application before the Delhi High Court, has not at all alleged that they are having, because the shares is worth is running to several crores. Several crores. They have not alleged anything that they are financially sound and able to mobilize funds to purchase the shares. So, frustrated by this, even though the GVK company has got a right of refusal, preemptive right, but in as much as they have failed to prove their financial capacity to purchase the property, it is not desirable to grant the relief of injunction for the enforcement of negative covenant, restraining the bid service division to transfer their share in favor of any third parties. So ultimately, the application filed by GVK company was dismissed. So what has to be? This is proviso to section 42. Section 42 of the Specific Relief Act, and the proviso says, provided that the plaintiff has not failed to perform the contract so far as it is binding on him. So the judgment of the Supreme Court is on this point. There is no breach on the part of the plaintiff. So he must establish his legal right, and he must establish that he has performed his part of obligation and his conduct is worthy and unblemished. So in the absence of proof of readiness and willingness on the part of the petitioner, he cannot get an order of injunction for the enforcement of negative covenant in an agreement, in the agreement. So this is very famous case, GVK Airport Holding Limited Company case. And another one, Indian Charge Chrome Limited versus Tata Iron and Steel Company Limited, 1996, 1 Calcutta Law Time, page 214. In this case, whether the negative part must be expressed in the agreement, or it can be inferred by necessary implication, or it can be implied. In this case, the Tata Iron and Steel Company Limited entered into an agreement with the Indian Charge Chrome Limited for the delivery of chrome and coke. In the agreement, there is a clause which says the TISCO has to make available the entire quantity of chrome ore and coke mentioned in the agreement. This is the positive. But the court has held that negative covenant, positive part in the agreement, necessarily implies a negative covenant that the TISCO shall not cease to make available the above quantities of chrome ore and coke on regular basis. So the court held, even in the absence of express negative covenant in an agreement, if it can be inferred by necessary implication that there is a negative covenant, then there is no problem for the court to enforce a negative covenant. To enforce the negative covenant. 1996, 1 Calcutta, Law Times, page 214. And the court further went on saying, it is well settled that in each case, the court should examine the substance of the agreement and not its form to ascertain whether there is a negative covenant. At this juncture, I would like to remember, normally the parties are entered into agreement in the form of lease or something in the form of license. A confusion will arise whether it is a lease deed or a license deed. Often the advocates are perplexed whether it is a deed of lease or deed of license. What is the difference? If it is a lease deed, there is a transfer of interest in the immovable property to enjoy the property for a particular period. Section 105 of Transfer of Property Act. If in this case of a license, as per Section 52 of the Indian Eastman, license is only a mere right to do something in or upon the property of other for a particular period. So in the case of lease, even after the expiry of the lease period, if the lessee continues to be in possession and enjoyment of the property, he is entitled to get an order of injunction, because he was inducted into possession of the property as a lessee for a particular period, and a notice to quit was issued, and he can only be evicted in the manner known to law. But in the case of license, it ceased the moment the period mentioned in the license period expires. Automatically, it will be revoked. So after the expiry of the license period, the licensee cannot get an order of injunction, even after the expiry of the license period. That is the law. But sometimes lease will be granted but the deed says it is a lease. The confusion will arise. I will give some example for license. If any license is given to catch a fish in a pond, this is only a license. What was given to you to catch a fish? You cannot claim any exclusive possession over the pond. When there is a multi-storied building, the entire key is with the owner, and in your one part you are allowed to do certain business. It's only a license. It is only a license. So licensee should depend upon the will of the licensor to carry out his business. And the right to vend prasadam in a temple, it is not a lease. Even though any place is segregated, to vend prasadam in a temple, it is not a lease, because once the temple is closed, the licensee cannot carry on his business. This is a license. So after the period of license, automatically it will come to an end. The licensee has no right to seek an order of injunction against the licensor. But in the case of lessee, it is not. So the test to ascertain whether it is a lease or license is known as litmus test. The science student might aware, but what is litmus test? So what is important, not the nomenclature of a particular document. What is the substance? So the Calcutta High Court has also held, even in the absence of express negative covenant, by necessary implication, it can be inferred that there is a implied negative covenant. Under those circumstances, it can be enforced. That is the dictum held by the Calcutta High Court in the case reported in Indian Charge Chrome Limited versus Tata Iron and Steel Company Limited. So, look at this citation. I am concluding my session on the enforcement of positive and negative part of the agreement. Vikas ji?
Yes, sir. I have shared the judgments.
Yes, you said.
I have reshared the entire.
On the line.
Yeah.
Get connected.
I said I have reshared the entire set of judgments, though we had separately also did it.
Hello?
I have shared the judgments which you have done separately as well as in a joint form.
You can circulate it separately or post it in the chat box.
We have done the both. And we will also share your answers to the questions which we had.
Yes.
And now we have Adi Lakshmi ma'am. Your popularity can be shown that Adi Lakshmi ma'am also had to be kept in a waiting list. Just like in the railway train, we have a reservation against cancellation. The moment somebody left, she got it. Yeah.
Thank you, my dear brother Vikas, for inviting me, and also the Legal Eagles Elite, and of course our beloved and most respected Shangar Murali sir. Whenever we call him, he's there to explain anything on the civil jurisprudence. He's an authority and encyclopedia. We are so happy that South and North is connecting time and again, and Vikas is doing a wonderful job. Almost pan-India and international level, people are getting connected to him. And it's a really wonderful session. Thank you, Shangar Murali sir. Your session was very excellent, and almost everyone got connected. What mistake I did was I was posting the link to everyone, failing to connect myself in. So the whole team got connected. I was left out. Without the captain, the ship started sailing because our captain, Mr. Shangar Murali sir, and Vikas was there. So it is real wonderful. But I was connected with your Facebook, and I was listening to the session throughout from the beginning. Even I couldn't connect the 100 participants. I was immediately on the Facebook and the YouTube. It is very useful, very nice session. Excellent one. Thank you so much. Thank you. We are very happy. And this COVID-19 situation and the lockdowns and all the vacation is going to be very productive on both the platforms of Legal Eagles Elite and the Beyond Law CLC. Thank you so much. And we will be getting connected time and again and bringing in more faculties down south. Thank you. Thank you so much.
Because is there any questions in the chat box? Then I will answer.
Yeah. Before going with the question, I'm telling that what we did, those question answers, which we had taken in the first five questions, we have divided into the YouTube. That question have been created a separate YouTube, and this session has been created as a separate session on the YouTube. This is by Chandrasekhar, whether suit based on premature agreement is maintainable. So whether a suit on the basis of premature agreement is maintainable.
Can you post it in the chat box?
I'll do that.
Ask them to post it in the chat box.
Here posted. I posted it.
You post it.
Have you read it?
Just I'm searching.
Last
Yes.
question.
Yes. The question is from Anil Kumar Tagi. Okay. Whether suit based on premature agreement is maintainable, kindly enlighten. A premature agreement is not maintainable because there must be some corresponding duties on the part of the, suppose, a vendor, the case of sale agreement, vendor and vendee. Premature agreement, suppose the clause says this agreement will take effect on particular point. Even prior to that, if any suit is filed, then the suit is premature. The suit on premature agreement is not maintainable. If any given case is given, then I can enlighten further. Next one.
No. We don't have any thing. Yeah. So
Any other questions posted in the chat box?
no, sir. None. I will just check it on the YouTube.
Yes.
Cancellation of a development agreement of a builder not willing to cancel the 5 years, not starting the work. What to do? It's not on the chat box. It's on the YouTube.
Is it the chat box?
No, it's on the YouTube. It says there's a builder and he's not building the property and neither cancelling the agreement. What can be done?
What is the question? Please repeat.
The builder has not built the building and he's not willing to cancel the agreement also.
Then it is open to the owner of the site to terminate the agreement and to sue against the builder for compensation. Read section 15 of the specific relief act in this aspect. Agreement has to be terminated, or the owner of the site is willing to engage the very same engineer builder, he can sue for specific performance, directing the builder to put up the construction as per the specification. If he is not willing, he can terminate the agreement and he can sue for damages.
And this is the last question. It says, no, this is a separate question. Yes. Kindly explain general damages and special damages.
General damages and special damages. It's a ocean. Yeah, I have to cover section 72 of the Indian Contract Act and special damages and general damages. Just I will give one illustration. I hope that it will useful to understand. Suppose you enter in an agreement with a builder. You are the owner of the site. You enter an agreement with a builder to put up house as per the specification attached to the agreement. The rates are specified like this. As in this earlier case, the builder refused to perform this part of obligation. He has not put up the construction as per the specification. And he left the work in the off-pay. Then the owner can terminate agreement and he can sue for damages against the builder. He can claim damages on two divisions. One is general, another one is special. General, on account of the breach on the part of the builder, he has suffered mental loss, mental agony. For your mental agony and mental loss, you cannot assess the exact value. So it can be tentatively valued according to your living standard. General. Special damages, and the work was not done. He left the construction work in the halfway, and the owner has to engage some other builder to put up the further construction, and the cost, the variation between the earlier agreement and the second one, comes under the special damages. He is entitled to get the special damages from the builder who has breached the agreement. Last version, a separate lecture is required to enlighten this aspect. What are all comes within the purview of general damages and the special damages.
So we will have a
special damages is the actual loss incurred by the party affected. General damages is loss of reputation and compensation for the mental sufferings.
Deepak Dongrai, can licensee be dispossessed of the premises once leave license agreement is expired by calling the police?
But please repeat the question.
I'm just repeating. I'm just posting it to the group.
Yeah. Can licensee be dispossessed of the premises once leave license agreement is expired by calling police authorities? Yes.
Next question.
Leave and license agreement is mainly entered into between the mobile companies to erect a tower on the private building. It's only a license. As I said earlier, license can be revoked after the expiry of the license period. It is automatic, need not be revoked. After the expiry of the license period, automatically the license will be revoked. It get revoked. Now, the question is whether the licensee be dispossessed of the premises once leave and license agreement is expired. You need not go to the police station. If you are able to dispossess the licensee with the help of your friends, you can do it. The licensee cannot file a suit and he cannot lodge a police complaint, provided in the decent manner he must be dispossessed. Suppose leave and license is given, you can disconnect the electricity, you can close the door, and you are a law-abiding citizen. You can go to the police station, lodge a complaint stating that I has given only license for a period of this year, for a period of 1 year or 2 years, as the case may be, and the period is expired. He is not leaving the place, and please help us to evict them. But normally this is civil in nature. Police will be very reluctant, and I think any other point is available. I will do some homework. Whether a writ to lie against the police to dispossess the licensee who is illegally occupying the premises after the expiry of the license period. But under law, licensee has no authority to remain in possession and enjoyment of the property after the expiry of the license period. That is the law. That is section 52 of the Indian Easement Act. But one exception is that suppose the licensee has made some improvement and made some improvement by way of erecting semi-permanent structure, then the license is irrevocable after the expiry of license period. It is irrevocable, provided there must be some permanent structure must be put up by the licensee. It's a special privilege. License is a special privilege. I have argued the case before the Madras High Court Murali bench. That is also reported. I don't know the citations. In 2016, 6 MLJ, I think so. I have argued what is the litmus test, how to distinguish the lease from license, what is the remedy available to the licensee if still in possession and enjoyment of the property after the expiry of the license. In that case, my client has given license to run a restaurant in the Tamil Nadu tourism by the Tamil Nadu Tourism Department in the place owned by the Tamil Nadu Tourism Department. After the expiry of the license period, they came and closed the door. So we filed the suit. Initially, we got the interim order. Subsequently, it was vacated. The matter went up to High Court. And the High Court said, no, you are only a licensee. What the licensor did, that is to close the door, is perfect. You can remove all your articles and leave the possession to the licensor. We can't help. So if it is a license, after the expiry of license period, licensee has no right to remain in possession of the property. He can be evicted, but in the manner known to law. In the manner known to law doesn't mean that you have to file a suit for eviction against the license. That is not at all necessary, because law does not recognize the licensee's right to remain in possession of the property after the expiry of the license period.
What is the limitation in case for rectification of instrument? Is suit maintainable after 20 years of the death of the executor of the deed? Second last question.
Rectification of instrument. 3 years limitation. One second. Yes. The period of limitation, if any fraud or mistake is committed, section 26 or the specifically fact, when through fraud or a mutual mistake of the parties, a contract or other instrument in writing does not express their real intention, then neither of the party or its representative in interest may institute a suit to have the instrument rectified. So, what is the period of limitation? Limitation Act article does not say this is normally the suit to set aside the instrument is 3 years from the date of execution of the instrument. That is also normally applicable to rectification of deed. But any fraud is pleaded, section 17 of the Limitation Act says, when fraud is pleaded, from the date of knowledge of the fraud, the period of limitation is 1 year from the date of knowledge of the fraud. When the plaintiff noticed that the fraud has been committed while executing this instrument, so he can sue for rectification or setting aside the instrument. He may be, the suit may be filed after the 20 years of the death of the executant, provided when he came to know the fraud committed by the other party. Section 17 of the Limitation Act.
The next question can be taken up.
Yes. Agreement of sale is executed between owner and purchaser for sale of land, and purchaser has to pay within 3 months balance sale consideration. But owner is supposed to survey by official surveyor of under office, and then only purchaser would purchase. But owner did not do survey in 3 months. Now 6 months elapsed, and owner is trying to sell to third parties. Notice is issued restraining owner not to sell. Purchaser said he is ready and willing to purchase, provided he does survey. What suit is to be filed? A suit for specific performance is must. In addition to that, you can pray for mandatory injunction directing the owner to survey the property with the assets of a qualified surveyor. Under section 21 of the specific LIP Act, section 22, in addition to the relief of specific performance, you can ask for a mandate injunction directing the owner to survey the property in your absence with the assistance of a qualified surveyor. Suppose another point, another dispute will arise. Suppose your agreement says that the property agreed to be conveyed is 1 acre of land, but only after the survey, if it is found that the property measures only 75 cents, 3.5 acre, 3 by 4 acre, then what is the remedy? You are not remediless. Section 12 of the Specific Relief Act, a degree for specific performance in part can be granted. Even though the agreement is in respect of 1 acre, you can ask for a specific performance in respect of 75 cents, and you are entitled to proportionately reduce the sale price. You have to file a suit for specific performance. Without filing a suit for specific performance, if you file a suit to survey the property before filing the suit for specific performance, that is not maintainable. In addition to the suit for specific performance, you can also pray for mandate injunction for survey.
I posted a last question.
Yes.
Yeah, just check it out.
Very interesting question. Testator executed a will to his wife for life, after then to his son, but son died before his mother's death. What is the position of the deceased son, legal heirs? So, the legatee died. Legatee died. That is, the beneficiary died. The legatee died before the other. So, no one is there to get the property. So the will is lapsed. If it is lapsed, the general rule of succession will apply. So the testator is deemed to be died intestate, even though he has executed a will. So he is deemed to be died intestate. So his class 1 legal heir is entitled to get the property. The wife, being the life estate holder, is the class 1 legal heir. He is entitled to get the property absolutely.
The last question is: testator executes a will in favor of his wife for life interest. After that, it was to go
Sir,
to
I
his
have
son.
answered this question.
No, but
Yes, no.
mother wants to transfer the share to her during her lifetime. What is the position of law?
Other?
Mother wants to transfer the share during his lifetime to the son. Last question. Should I read it?
Sir, this is my first question. Mother cannot transfer his life interest according to section 6H.
Somebody has posted, what about section 14 under the Hindu Succession Act?
Once life estate is given, he cannot transfer, assign, relinquish, release. She can't do.
Okay.
That is my first problem. Question number 1.
Yeah. Okay. So we don't have any
another question is.
No.
A debtor sold out the property after filing the suit for recovery of the money by creditor with an intention to make delay the debtor as not other properties, except that what is the remedy? Yes, very good question. Take section 53 of the Transfer of Property Act. If the debtor transfer the property with an intention to cheat and defraud the creditor, then such a transfer is a fraudulent transfer. You can file a suit to set aside the fraudulent transfer and recover the amount by attaching the said property.
Last question: forfeiture of deposit for non-performance of contract. Is this in nature of compensation for non-performance?
Forfeiture of deposit for non-performance of contract, is this in nature of compensation for non-performance? This section 23 of the Specific Relief Act. Suppose the agreement contemplates forfeiture of advance amount in the case of non-performance. So, non-performance, a particular sum is quantified as compensation, namely the advance sum. The point is, can the vendor forfeit the advance amount on account of the non-performance on the part of the purchaser? This is question number 1. But section 23 says the forfeiture clause is for the compelling the purchaser to perform his part of contract, that the perpetual clause is inserted, then the court is entitled, the court has got power to grant a specific performance, degree for specific performance, if the suit is filed by the purchaser for specific performance. If the specific performance, he can, in addition to that, he can also claim damages. But here, non-performance on the part of the purchaser. Purchaser can terminate the agreement. Purchaser can terminate the agreement. As per the clause in the agreement, he is entitled to perpetuity deposit amount. Then he has to keep silent. Then the suit will be filed either for the specific performance or for the return of the advance amount. Then the vendor has to defend, make a defense that he has quantified the amount as damages. So I am rightly perpetuated that amount. He need not file any suit. He can simply perpetuate the amount and keep silent. And if any suit is filed, he can take it as a defense.
What is the limitation to file suit under Section 53 of the TPA Act?
53 of the TPA Act. When you came to know the fraudulent transfer within a period of 3 years.
Okay. So thank you, sir, for giving your insights. If Adi Lakshmi is there, then we can.
Because G.
Yeah.
Because G.
Yes, sir.
The next lecture onwards, I have to work hard because your participants are very brilliant, posting question after questions. Those questions I am unable to answer those questions. I have to work hard. I have to read more. I have to enrich myself. I have to enlighten myself. I have to read again and again. The participants are very brilliant.
Everybody is learning in that process. And you are able to answer it. It shows the volume of knowledge you have.
Yes.
Yeah, Adi Lakshmi ma'am is to unmute. Yeah.
Yes, Vikas, thank you. Thank you for calling in. So excellent. Sir, Shankar Murali, sir, you know answers for everything, sir. Whatever question it's shoot up, you just come up with brilliant answers. And of course, Vikas, you're doing wonderful job. You're bringing in so many new topics and so many excellent legal luminaries as speakers, and it is excellent to listen to your topic and day in and day out. And tomorrow also someone from South is doing a session. They had asked me to post it in Legals Allied. So even though yes, I have got a request from his junior or someone today evening that the posters has to go on our Legals Allied platform. We are really eager to do it, and it's pleasure to get connected to you. Thank you, Shankar Murali sir. Thank you so much. And a special thanks to his junior Harita, who does everything, helping all, getting all the citations.
Today is not with me. He's writing LLM exam. He's at Trichy.
But you have, sir, you have your daughter by your side to support, sir.
He is also right. He is also on the online examination.
Yes, sir. We are all there to support, sir. The Legals Allied family is all with you and beyond Law CLC, sir. Thank you so much, sir. Thank you, Vikas. And thank you, every one of you, for joining in. Thanks to the Legals Allied team for joining in huge number. Thank you. Thank you, everyone.
Thank you, Vikasji. Thank you, Altashi madam.
So before we part for the day, tomorrow's session is Admissibility of Documents, Marking and Exhibition by K. Prabhakar, an advocate from Madurai High Court. So do stay connected with us at tomorrow 5:30 p.m. And one of the sessions, like we had with Mr. Shangar Murali, Mr. Mukant is taking a very simple, making the definitions under the Transfer of Property Act. Next week he is coming. Definitions of Transfer of Property Act. Very simple. So do stay connected with us, and everyone stay safe, stay blessed, keep on wearing your masks, maintain social distancing, and those who have not done the vaccination, kindly do the same. And stay safe, stay home, and we will keep on sharing the legal knowledge. But at the same time, you shouldn't go outside the home. You all know that breaching the Lakshman Rekha, what can be the result. Everyone stay safe. Thank you. And thank you to Mr. Murali and to all those participants who have been watching us live on the Facebook, YouTube, and on this platform. And for the participants, they might feel that why there are two YouTube uploads of this particular session. We have divided the first 5 questions into one particular session that's already uploaded, and this session separately, wherein we took section 42 and thereon. That has also been uploaded separately. So those who want to look into those 5 questions have to watch that YouTube channel uploading separately and this one separately. Thank you, sir, for sharing your knowledge. And thank you, Adi Lakshmi ma'am and the entire team of Legal Elites. Thank you.